Gaming, Parimutuel Wagering, and Breeding Law, Section 102, provides that the New York State Gaming Commission shall consist of 7 members appointed by the governor, by and with the advice and consent of the Senate. 4 members confirmed by the New York State Senate are necessary to afford the commission an ability to establish quorum and to undertake action. This present meeting of the commission is now called to order. This meeting is being conducted in conformity with Governor Andrew M. Cuomo's Executive Order number 202.1, which is entitled Continuing Temporary Suspension and Modification of Laws Relating to the Disaster Emergency. The order suspended portions of the Open Meetings Law and specifically allows the conduct of meetings by telephone or other similar service. The Governor's Executive Order in relevant part reads, Article 7 of the Public Officers Law, to the extent necessary to permit any public body to meet and take such actions authorized by the law without permitting in-public, in-person access to meetings and authorizing such meetings to be held remotely by conference call or similar service, provided that the public has an ability to view or listen to such proceeding and that such meetings are recorded and later transcribed. By Executive Order 202.72, Governor Cuomo extended the authority of Order 202.1 through December 3rd, 2020. Accordingly, this commission meeting is being conducted in conformance with such allowance, and we are recording today's meeting for transcription as required. Ms. Secretary, will you please call the roll?
John Crotty.
Present.
Peter Machete.
Here.
John Paklemba.
Here.
Barry Sample.
Here.
Jerry Skurnick.
Here.
Ms. Secretary, please have the record reflect that a quorum of qualified members is present, thus enabling the transaction of business. Chairman Sample has requested that Commissioner Machete preside over today's meeting. Unless there is an objection, Commissioner Machete.
First matter is consideration of minutes for the meeting of October 19, 2020. Those minutes have been provided to the members in advance. I'll ask the members if there are any edits, corrections, or amendments. Hearing none, Ms. Secretary, please let the record reflect that the minutes were accepted. The second matter is rulemaking. New York State Racing, Parimutuel Wagering, and Breeding Law, Section 104.19 authorizes the Commission to promulgate rules and regulations that it deems necessary to carry out its responsibilities. Therefore, the Commission will, from time to time, promulgate rules and rule amendments pursuant to the State Administrative Procedure Act. And today we have numerous rules for adoption or proposal, and I would ask Mr. Williams to please outline the first item.
For Commission consideration is adoption of a rulemaking to conform to the requirements in New York Public Officers Law, Section 87.4a, which directs state agencies to promulgate rules to prescribe the way the agency will safeguard against any unauthorized access to records containing trade secrets submitted. The proposal also conforms the time to determine records access appeals within the agency to the time prescribed by statute, allows for the delivery of appeal decisions by electronic mail, and adds cross-references to statutory requirements. The notice of proposed rulemaking was published in the August 19, 2020 State Register, meaning the public comment period for this proposed rulemaking expired on October 19th. No comments were received. Staff recommends that the Commission adopt this rulemaking.
Commissioners, any questions on the adoption of the rule regarding an agency rule for the protection of trade secrets submitted to the Gaming Commission?
No.
Hearing none, may I have a motion to adopt this rule?
So moved.
Second?
Second.
Any discussion on the motion? Hearing none, all in favor?
Aye. Aye.
Any opposed? The motion carries. Next item.
For Commissioner consideration is adoption of a rulemaking to add a feature called Money Dots to the existing Quick Draw game. In the standard Quick Draw game, a patron may choose to play between 1 and 10 spots or numbers per game. A draw of 20 numbers is made from a field of 80, with players winning prizes depending upon how many of their chosen numbers match the 20 winning numbers drawn. The Money Dots feature allows a patron to make a $1 wager and receive a Money Dots ticket containing 8 random numbers from 1 to 80. While this wager is independent of any wager on the base quick draw game, it runs alongside the base game. After the 20 winning quick draw numbers are revealed, the remaining 60 are assigned a color and corresponding prize value. Following assignment, one randomly selected Money Dots number will be selected, and any player whose Money Dots ticket contains the selected Money Dots number wins the corresponding prize amount. The proposal also includes reorganization of the quick draw rule and other technical and stylistic revisions. The notice of this proposed rulemaking was published in the September 2nd State Register, meaning the public comment period for the proposed rulemaking expired on November 2nd. No comments were received. Staff recommends that the Commission adopt this rulemaking.
Commissioners, any questions on the adoption of a rule regarding the addition of the feature to the quick draw lot game called Money Dots? Hearing none, may I have a motion to adopt this rule?
So moved.
Second?
Second.
Any discussion on the motion? Hearing none. All in favor?
Aye. Aye. Aye.
Any opposed? The motion carries. Next item.
For Commission consideration is adoption of an amendment to the Commission rule that sets forth standards for housing maintained on the grounds of certain racetracks. Specifically, the proposal would extend existing regulations governing housing on the grounds of the New York Racing Association, Inc., to all housing at Thoroughbred and Standardbred racetracks. This would bring standardization to housing at Buffalo, Finger Lakes, Monticello, Saratoga Harness, Vernon Downs, and Yonkers. Neither Batavia nor Tioga offer housing. The proposed rule would provide, among other things, standards for building and residential rooms, sanitary, water, garbage removal, and pest control, and is generally modeled after the New York State Department of Health's migrant farm worker housing regulations. The notice of proposed rulemaking was published in the September 2nd State Register, meaning the public comment period for the proposed rulemaking expired on November 2nd. No comments were received. Staff recommends that the Commission adopt this rulemaking.
Any questions on the adoption of a rule regarding backstretch housing standards at the racetracks?
No, I just wanted to commend the chairman and commission staff for addressing this issue and actually going and viewing the existing housing and making this rule so that the conditions will be required to meet the standards and alleviating some of the problems that we've had in the past.
So noted, John. I think we all agree. A lot of work went into that. Thank you, Barry and Rob and the staff.
Well, thank you. Thank you, John, a great deal. The workers are very important.
May I have a motion to adopt this rule?
So moved.
So moved.
Second?
Second.
Any further discussion on the motion? Hearing none, all in favor?
Aye. Aye.
Any opposed? The motion carries. On to the next item.
For Commission consideration is adoption of a rulemaking to remove certain penal aspects of horses coming off and returning to LASIX administration. As you might recall, certain racetracks have considered karting races wherein a condition will be no horse receives race day LASIX administration. Present rules allow a horse to be removed from the LASIX administration list, but only allow return after an additional bleeding incident which triggers a mandatory horse layoff. This penal aspect may chill a trainer's willingness to experiment in running their charge without LASIX. Accordingly, this proposal would permissively allow a horse to be removed from the LASIX eligible list for the limited purpose of competing in a non-LASIX race and allow the return to the list without incurring any potential mandatory layoff. The notice of this proposed rulemaking was published in the September 2nd State Register, meaning the public comment period for the proposed rule expired on November 2nd. One comment was received from NYRA, which indicated support for adoption. Staff recommends that the commission adopt this rulemaking.
Any questions on the adoption of the rule regarding promotion? Otherwise known as LASIK, use and practice? Hearing none, may I have a motion to adopt this rule?
So moved.
Second?
Second.
Any discussion on the motion? Hearing none, all in favor?
Aye. Aye.
Any opposed? The motion carries.
For commission consideration is adoption of a rule that would strengthen regulations related to exercise-induced pulmonary hemorrhage, or EIPH, in thoroughbred racing. Under the proposed rule, trainers will be required to maintain a record of serious EIPH episodes, which are defined by the universally used 1 to 4 grading system, and epistaxis, which is visible bleeding from the nostrils. Records created pursuant to the amended rule would be required to be maintained by trainers for 4 years unless given to a subsequent trainer or owner or reported to the commission. The commission would establish a reporting system to collect such information from trainers. For convenience of reporting, a trainer may delegate this reporting duty to their treating veterinarian. In general, the most salient portions of the rule proposal requires that a horse that has experienced a serious EIPH episode must be subjected to another endoscopic examination following their next race or workout, and requires trainers to provide such information to subsequent owners or their agents or trainers within 48 hours of a request for information, unless the commission has collected and provided the information itself. Which is visible bleeding from the nostrils. The proposal would also pursuant to the amended rule would be required to be made. You got a little back. There we go. The proposal would also codify the standard practice of excluding a horse that experiences epistaxis for a specific minimum time period. The notice of proposed rulemaking was published in the September 2nd State Register, meaning the public comment period for the proposed rulemaking expired on November 2nd. One comment was received from NYRA. NYRA stated that while it supported the objective of the proposed rule, it objected to the proposal as written, since they believed the proposal lacked an enforcement mechanism. Staff disagreed that the proposal lacks an enforcement mechanism, as Racing Law Section 220.2 and Commission Rules 4002.1C, 4002.9A, and 4022.12 all authorize appropriate penalties for administrative discretion and the adjudicatory process. Staff recommends that the Commission adopt this rulemaking.
Any questions on the adoption of a rule regarding exercise-induced pulmonary hemorrhage protections for thoroughbred horses? Hearing none,
No.
may I have a motion to adopt this rule?
So moved. So moved.
Second.
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 Any discussion on the motion?
Third.
Hearing none but the third. All in favor?
Aye.
Aye.
Any opposed? The motion carries.
For Commission consideration is the adoption of a new wager for harness racing. The wager, to be called the Jackpot Super High Five, requires the selection of the first 5 finishers in a single race in the correct order of finish. The entire pool would be paid to a bettor with a unique winning ticket if there is only one ticket. If there is not one ticket, only one winning ticket, then the net pool would be split into a major pool and a minor pool. The major pool would be a carryover into the next Jackpot Super High Five pool, and the minor pool would be divided among winning wagers. If there are no winning wagers, both the major pool and the minor pool would be carried over to the next Jackpot Super High Five pool. The rule would also provide for contingencies in the event of dead heats and races with fewer than 5 betting interests. The triple wager rule would be renumbered to enhance the organization of the park. The notice of proposed rulemaking was published in the September 2nd State Register, meaning the public comment period for the proposed rulemaking expired on November 2nd. No comments were received. Staff recommends the Commission adopt this rulemaking.
Any questions on the adoption of a rule regarding jackpot super high five wager for harness racing? Hearing none, may I have a motion to adopt this rule?
So moved.
Second?
Second.
Any discussion on the motion? Hearing none, all in favor?
Aye.
Aye.
Any opposed? The motion carries.
For commission consideration is the adoption of a new wager for harness racing. The wager, known as a jackpot or rainbow wager, appeals to bettors by giving a larger prize when there is only one winning wager from a pool. If there are more than one winning ticket, then the major portion of the day's pool is paid out to those who selected 6 of 6 winners, and the minor pool is added to the carryover. The carryover gets paid out when there is a unique winning ticket or when there is an intermediate or final distribution as approved by the commission, which would typically occur at the end of a racing meet. The notice of proposed rulemaking was published on September 2nd in the State Register, meaning the public comment period expired on November 2nd. No comments were received. Staff recommends that the commission adopt this rulemaking.
Any questions on the adoption of a rule regarding a pick-six jackpot wager for harness racing? Hearing none, may I have a motion to adopt this rule?
So moved.
Second?
Second.
Any discussion on the motion? Hearing none, all in favor?
Aye.
Any opposed? The motion carries.
For commissioner consideration is the adoption of a rulemaking that may be colloquially referenced as rider licensing health and safety package. The proposal is designed to strengthen the health and fitness protections and upgrade the licensing requirements for jockeys, apprentice jockeys, exercise riders, and outriders who ride in thoroughbred or steeplechase horses. Several aspects of licensure are currently applied to riders and will be made explicit, including demonstrative familiarity with horse care and general horsemanship, and not permitting an injured or sick person to return to work without appropriate clearance. The proposal also creates a rider fitness component that details the kind of medical issues that must be disclosed and subjected to a medical examination and clearance before a rider may be licensed. A key aspect of the rulemaking is to require every rider to document their baseline concussive status, to undergo another sports concussive assessment tool, or SCAT, examination after any fall from a horse or possible head injury, and to make a permanent record of all SCAT examinations. The proposal also creates a mandatory fitness to return to ride program to require an appropriate medical examination and clearance before a rider may return to riding after a concussion or other significant medical issue. Riders will also be required to carry a medical information card that will help medical providers locate the rider's prior medical history and provide appropriate medical care. Finally, the proposal requires a commission license, not just one from the National Steeplechase Association, for steeplechase jockeys, applies the improved health and fitness standards to them, and precludes inexperienced steeplechase jockeys from participating in the most competitive and dangerous races with parimutuel wagering. The notice of proposed rulemaking was published in the September 2nd, 2002 State Register, meaning the public comment period for the proposed rulemaking expired in November 2nd. No public comments were received. Staff recommends that the commission adopt this rulemaking.
Any questions on the adoption of a rule regarding medical fitness of thoroughbred horse riders and steeplechase jockeys alike? Hearing no discussion, may I have a motion to adopt this rule?
So moved.
Second?
Second.
Any discussion on the motion? Hearing none, all in favor?
Aye.
Aye.
Any opposed? The motion carries. Next item.
For commission consideration or adoption of amendments to rules governing the triple wager rule in harness racing. The triple wager requires the selection of the first 3 finishers in a single race in the correct order of finish. The proposed amendment would reduce the minimum number of entries in a race for which the triple is permitted from 6 to 5. Other stylistic and clarifying amendments are also proposed for consistency with other rules. The rule would also be renumbered to accommodate the previously approved jackpot super high five wager. The notice of proposed rulemaking was published in the September 2nd State Register, meaning the public comment period for the proposed rule expired on November 2nd. No comments were received. Staff recommends that the Commission adopt this rulemaking.
Any questions on the adoption of a rule regarding triple wager and harness racing? Hearing none, may I have a motion to adopt this rule?
So moved.
Second?
Second.
Any discussion on the motion? Hearing none, all in favor?
Aye. Aye.
Any opposed? The motion carries.
For Commission consideration is adoption of a rule that requires thoroughbred trainers to keep a record of medications administered by the trainer after having been dispensed by veterinarians. Veterinary records available generally contain no record of administration. This proposal exempts anti-ulcer medications commonly added to feed and other non-injectable drugs rated harmless by the Association of Racing Commissioners International. The proposal would also allow the Commission to require trainers to keep such records in a particular form and to make records available for inspection for a period of 6 months. This notice of proposed rulemaking was published in the September 2nd State Register, meaning the public comment period expired on November 2nd. No comments were received. Staff recommends that the Commission adopt this proposed rulemaking.
Are there any questions on the adoption of a rule regarding the requiring of a log of drugs administered by thoroughbred horse trainers? Hearing none, may I have a motion to adopt this rule?
So moved.
Second?
I quit.
Second.
Any discussion on the motion? Hearing none, all in favor?
Aye.
Aye.
Any opposed? The motion carries. Next item.
For Commission consideration is adoption of a rule restricting the administration to thoroughbred horses of non-steroidal anti-inflammatory drugs, or Nsaids, such that only one clinical dose may be administered during the week before the horse races. The proposal would limit the administration to an intravenous treatment and adopt stricter thresholds for the two most commonly used Nsaids, lamixin and phenylbutazone, as has been recommended by the Racing Medication and Testing Consortium and adopted as a model rule by the Association of Racing Commissioners International. The proposal also reduces the list of Nsaids that can be administered lawfully within 1 week before a horse races to only 3 by eliminating the Nsaids that are not widely used and for which the appropriate laboratory threshold is unclear. Current rules permit the use of 2 Nsaids from among a list of 6 Nsaids allowed during the week before a horse races if one is not used within 96 hours of the race and the other is administered outside 48 hours. The notice of proposed rulemaking was published in the September 2nd State Register, meaning the public comment period for the proposed rule expired on November 2nd. No comments were received. Staff recommends the Commission adopt this rulemaking.
Any questions on the adoption of a rule regarding restricting NSAID use in the thoroughbred race? Hearing none, may I have a motion to adopt this rule?
So moved.
Second?
Second.
Second.
Any discussion on the motion? Hearing none, all in favor?
Aye.
Any opposed? The motion carries. Next item.
For Commission consideration is adoption of a rule that would apply wagering restrictions to certain employees of casino vendor registrants identical to restrictions that apply to employees of a casino. Under state laws and regulations, a casino key employee may not wager at any casino in the state, nor may any other casino employee directly involved in the conduct of gaming operations or who holds a gaming employee registration in the same casino where they are employed, or in any casino owned or operated by the employing casino or an affiliate. The public comment period expired on November 2nd, 2020. One public comment was received from Rivers Casino and Resort. They opposed the proposal. Rivers raised general concerns about restricting play, writing that if a vendor employee is qualified under the applicable licensing and registration standards, the employee should be deemed to have the character and financial stability to gamble as a casino patron, and argued that a vendor employee involved in gaming operations would have no advantage in the playing of games over other patrons. Rivers also asserted the potential difficulty with rule application, writing that their employees would have difficulty enforcing such a gaming restriction as they would not know who a vendor employee might be. They also raised a concern with jeopardy or with enforcement responsibility, questioning whether a licensed casino might jeopardize their license if a vendor employee violated the restriction. Rivers also objected to the concept of impropriety, appearance of impropriety being used with the Commission's regulatory impact statement, arguing that the term is antiquated, that patrons would not likely ever know that a prohibited employee was playing, and that the concept should not apply to private businesses. Finally, Rivers asserted that there would be a cost to the rule, insofar as restricting a potential patron from playing would mean a casino would forego gaming revenue, and as a result, the state would lose tax revenue. The purpose of the proposed rule is to standardize gaming restrictions by treating all persons who perform gaming-related roles at a casino similarly, whether employed by the casino itself or by a casino vendor. Restricting certain employees from gambling advances the policy of promoting public confidence in the integrity of gaming. A casino employee gambling and winning at a casino has the potential to diminish public confidence in the fairness of the gaming activity, even if, in fact, there is no actual advantage to the casino employee who plays. While we appreciate that each licensed vendor employee has been qualified under the applicable licensing and registration standards, staff notes that the standards are to perform the role of servicing a casino and not standards for participating in gaming. As to revenue implications, staff does not believe that revenue calculations should drive an integrity-related rule. We note that the casinos presently forego revenue when they comply with other wagering restrictions, such as from underage patrons, self-excluded persons, involuntarily excluded persons, and their own employees. Finally, staff believes that enforcement of this rule would be a joint responsibility of the Commission, its licensees, and the restricted employees. The restricted employee and the vendor and the casino might be culpable for a violation, depending on the facts and circumstances of any given violation. Staff recommends that the Commission adopt this proposed rule.
Are there any questions on the adoption of a rule regarding restrictions on wagering by key employees of casino vendors?
No.
Hearing no discussion, may I have a motion to adopt this rule?
So moved.
Second.
Second.
Any discussion on the motion? Hearing none, all in favor?
Aye. Aye.
Aye.
Any opposed? The motion carries. Next item.
For Commission consideration is adoption of revisions to the Thoroughbred out-of-competition sample collection rule intended to conform our existing rule to the national model rule of the Association of Racing Commissioners International. In general, the out-of-competition rule protects race integrity by making it possible to collect samples from horses that are engaged in horse racing but are not entered to race or on the grounds of a licensed racetrack. Such samples allow the Commission to detect administration to racehorses of drugs in violation of Commission rules, particularly potent doping agents that increase red blood cells, drugs that mask pain, or increase a horse's ability to race beyond its natural limits. The notice of proposed rulemaking was published in the September 2nd State Register, meaning the public comment period for the proposed rule expired on November 2nd. No public comments were received. Staff recommends that the Commission adopt this rulemaking.
Are there any questions on the adoption of a rule regarding the amendment of the out-of-competition testing rule for thoroughbred racing? Hearing none, may I have a motion to adopt this rule?
Motion.
Second?
Second.
Any discussion on the motion? Hearing none, all in favor?
Aye.
Any opposed? The motion carries.
For Commission consideration is a rulemaking proposal to control the improper use of the bronchodilator clenbuterol. Clenbuterol is a beta-2 antagonist that in the United States is not approved for human use. It is only approved for use in horses to treat lower airway disease. Clenbuterol has a secondary mode of action, a repartitioning effect that causes the body to build more muscle and reduce the fat content of the body. This effect may last for 2 months after a treatment is discontinued. While it is unclear whether long-term use will improve race performance, the potential to abuse the drug for a performance-enhancing effect is undeniable. Staff notes that the World Anti-Doping Agency and the International Olympic Committee have banned its use in human athletes as a performance-enhancing drug. Due to its potential use as a performance-enhancing drug, clenbuterol has been regulated by the Commission. With thoroughbred horses, the Commission allows the use of clenbuterol under a therapeutic use exemption. Commission rules provide that a horse may not race for at least 14 days following clenbuterol administration. This requires a prescription by an attending veterinarian and recordation in veterinary records. With standardbred horses, clenbuterol administration also requires a prescription by an attending veterinarian and recordation in veterinary records, but its administration is allowed until 96 hours before scheduled post time of the race in which the treated horse is to compete. This is allowed since harness horses generally race weekly, which exposes a horse to drug testing that identifies clenbuterol administrations within the preceding 2 weeks through urinalysis and 96 hours with plasma testing. The standardbred rule also provides an exception for horses required to qualify without performance within 30 days or which has not yet raced after qualifying. These horses may not race at all for at least 14 days following an administration of clenbuterol. If the harness horse does not race for 30 days, it is subject to the 14 days following clenbuterol administration prohibition. This rulemaking proposal regarding the acceptable use of clenbuterol was born from data analyzed by Equine Medical Director Scott Palmer, who reviewed out-of-competition samples from horses trained by individuals indicted by the U.S. government this past March. Recall that each horse was required to submit a hair sample to be tested for prohibited and impermissible substances prior to the horse being allowed to return to racing. The review found clenbuterol was administered to a substantial number of these horses without evidence of a medical prescription. Following Dr. Palmer's presentation of his findings at a meeting attended by more than 60 stakeholder leaders as part of the Mid-Atlantic Strategic Plan to Reduce Equine Fatalities, the Mid-Atlantic racing stakeholders unanimously approved a proposal to have jurisdictions consider implementation of a new clenbuterol rule designed to significantly reduce its improper use. Maryland began its rulemaking process on October 22nd and will extend a similar rule to both thoroughbreds and standardbreds. Pennsylvania has indicated it will soon commence regulatory change, and it is expected that Delaware, New Jersey, and Virginia will also consider the rule proposal. West Virginia indicated that they would change their rule through its legislature where the approval is required. This proposed rulemaking will require written regulatory approval before a horse in racing or in training may be treated with a prescribed clenbuterol. Required daily submission of the administration of any clenbuterol treatment result in a treated horse being placed on the veterinarian's list and barring the horse from returning to racing until it tests negative for clenbuterol in both blood and urine. Staff recommends that the Commission propose this rulemaking.
Are there any questions on the proposal for rule regarding clenbuterol use revision? Hearing none, may I have a motion to propose this rule?
So moved.
Second?
Second.
Any discussion on the motion? Hearing none, all in favor?
Aye.
Aye.
Any opposed? The motion carries. Next item.
For Commission consideration is a proposed emergency and consensus rulemaking to explicitly enable qualified authorized organizations lawfully conducting charitable gambling to accept, if they so choose, payment for chance by personal check, credit card, or debit card. This change will allow organizations seeking to implement contactless payment to readily do so.
Commissioners, any questions on the emergency and consensus proposal of a rule regarding payment methods in charitable gaming? Hearing none, may I have a motion to propose this emergency and consensus rule?
So moved.
Second?
Second.
Any discussion on the motion? Hearing none, all in favor?
Aye.
Aye. Aye.
Any opposed? The motion carries.
For Commission consideration is a proposed consensus rulemaking to eliminate the requirement in charitable gaming that a person participating in the management or operation of games of chance be a bona fide member of the organization, the authorized organization, or auxiliary organization for at least 1 year prior to the organization's license period. This proposal will harmonize the participation requirement in games of chance with that required for general participation in bingo, and will allow for greater participation in such games.
Any questions on the consensus rulemaking for participation in charitable gaming games of chance? Hearing none, may I have a motion to propose this rule?
So moved.
Second?
Second.
Any discussion on the motion? Hearing none, all in favor?
Aye.
Opposed? The motion carries. The next matter is going to be adjudications. Today we have one item for adjudication, and I'll ask Mr. Williams to outline that.
Philip Flewitt's harness racing license was suspended for 8 days following a race wherein, as a driver, he slowed his horse past the quarter-mile mark at Saratoga Raceway, causing other horses in the race to take up abruptly and break stride, all in violation of rules 4,117.4I and 4,117.4M. Mr. Flewitt disputed this ruling as unjust and requested a hearing. Following adjournment by party agreement, a hearing was conducted on September 30th, 2020. The hearing officer found that Mr. Flewitt had violated Rule 4117.4I, but that mitigating circumstances, namely a provisional driver ran his horse too fast in trying to fill a gap, necessitated a lesser penalty of 3-day suspension, with the penalty suspended for a period of time not to exceed 6 months, provided Mr. Flewitt does not violate any commission rule. The commission considered this matter at a meeting conducted pursuant to a judicial or quasi-judicial proceedings exemption of New York Public Officers Law, Section 108.1.
The commission duly deliberated and considered this matter and determined upon a vote of 5-0 to sustain the hearing officer's report and recommendations. Next, we have new/old business. First, the old business. With pertaining to the use of the crop, we've had a great deal of discussion about this, running for a considerable amount of time. We are going to ask the staff to draft options for the limitation of the use of the crop during racing so that we may have further discussion on the matter. And I'm told that can be done fairly soon.
Yes.
Right.
And could I have a suggestion that we also have Dr. Palmer intimately involved in that process?
Certainly.
Thank you.
New business. Racing surfaces. We have reviewed some of the correspondence that the commission received during the last 2 months and noted a theme among a few pieces. Specifically, we've read that a few harness horsemen's organizations raised concerns with the maintenance and condition of either the racing or training surfaces. In discussion with staff, we have found that it appears all concerns have been resolved, but our observations indicate that the commission's rules do not provide any objective standard for racing surface maintenance or condition. Accordingly, we'd like to ask staff to undertake some research and consult with those who condition or use racing surfaces and consider language for a potential rulemaking.
We can certainly do that.
So that concludes today's published agenda. I want to thank everyone who participated. Do any commissioners have any items they'd like to present for consideration?
Well done, Mr. Chairman, Mr. Temporary Chairman.
Yeah. Thank you, John. The commission traditionally has met on the fourth Monday of each month, which for December would be the 28th. Given the holidays, if workload suggests action are needed, perhaps we should consider a mid-December date. For planning purposes, Secretary Buckley will be in contact to consider those various availabilities. So anything else, guys? Hearing no other items for consideration, this meeting of the New York State Gaming Commission is adjourned. Thank you so much.
Thank you, Mr. Chairman.